arbitrators. However, an arbitration clause cannot mandate the other party to select its arbitrator from the panel curated. C. A clause that allows one party to unilaterally appoint a sole arbitrator gives rise to justifiable doubts as to the independence and impartiality of the arbitrator. Further, such a unilateral clause is exclusive and hinders equal participation of the other party in the appointment process of arbitrators. D. In the appointment of a three-member panel, mandating the other party to select its arbitrator from a curated panel of potential arbitrators is against the principle of equal treatment of parties. In this situation, there is no effective counterbalance because parties do not participate equally in the process of appointing arbitrators. The process of appointing arbitrators in court is unequal and prejudiced in favor of the railways. E. Unilateral appointment clauses in public-private contracts are violative of Article 14 of the Constitution. F. The principle of express waiver contained under the proviso to Section 12(5) also applies to situations where the parties seek to waive the allegation of bias against an arbitrator appointed unilaterally by one of the parties. After the disputes have arisen, the parties can determine whether there is a necessity to waive the nemo judex rule. And G. The law laid down in the present reference will apply prospectively to arbitrator appointments to be made after the date of this judgment. This direction applies to three-member tribunals. The reference is answered in the above terms. My judgment is on behalf of Justice Pardiwala, Justice Manoj Mishra, and myself. There are two other opinions. We have all reached to the same conclusion. So, in some measure, the other judgment is by Brother Justice Rishikesh Roy, and the third judgment by Brother Justice P.S. Narasimhan. Thank you.
I have read the scholarly judgment of the learned Chief Justice CJI Chandrachud and also the erudite one authored by Brother Justice P.S. Narasimhan. I am in agreement with the view of the learned Chief Justice that principles of equality under Section 18 of the Arbitration Act applies at all stages of the proceedings, including the stage of appointment of arbitrators. His judgment offers a thorough examination in Part D of the mandatory provisions within the model law and the Arbitration Act, which underscores the applicability of the equality principle, and the same is not reiterated here for the sake of brevity. It is also correct to say that Arbitration Act does not provide special or different treatment to government or government undertakings involved in arbitration. Nonetheless, it is not possible for me to agree with the view canvassed that the principles of constitutional law can be invoked to reinforce the equality doctrine in the realm of arbitration. On this aspect, Justice Narasimha has rightly opined that public law principles evolved in constitutional and administrative law should not generally be imported to arbitration law. Anchoring the principles of equality among the arbitrating parties from the framework of Arbitration Act, rather than invoking constitutional and administrative law principles, in my opinion, will not only preserve impartiality in the appointment of arbitrator, but will also ensure party autonomy. It is also imperative to observe that courts should exercise judicial restraint at the threshold stage of appointing an arbitrator. This will then safeguard the core principle of equality, party autonomy, and minimal judicial intervention in the arbitration domain. To lend credibility to the arbitral process, statutory procedural safeguards promoting basic fairness must be given full play. A key factor in establishing an arbitrator's legitimacy lies in ensuring independence and impartiality at all stages of the arbitral process. At the same time, excessive judicial intervention must be avoided. By striking this balance between procedural protection and judicial restraint, we can reinforce the arbitrator's role as an autonomous system capable of delivering justice on par with traditional courts. Importantly, the Arbitration Act does not per se prohibit unilateral appointment of arbitrators. if those nominated in the panel fits into the limiting factors underscored in section 12(5), read with 5th and 7th schedule of the Act, the same will not upset the level playing field to be provided to the arbitrating parties. The 2015 amendment addressed specific concerns regarding fairness, potential advantage to one party, as well as independence and impartiality of an unilaterally appointed arbitrator under the IBA guidelines. An eligible arbitrator not otherwise disqualified under Schedule 7 of the Act can be appointed unilaterally, and the court should refrain from imposing their own opinion, countermanding the clear intent of the parties. The statutory safeguards under the Arbitration Act provide a checklist and a counterbalance, and thereby rule out inequality for the arbitrating parties. Concerns about presumed bias of an arbitrator nominated by the claimant must also be tested against the objective standard of independence and impartiality provided under the 7th schedule of the Arbitration Act. The appointment of arbitrators must scrupulously be made through the consent of the parties. The recourse to sections 11 must not be readily inferred in view of the remedies contained in section 12, 13, 14, and 15 of the Act. In any case, the scrutiny on whether to intervene has to be on a case-to-case basis. Arbitration without party autonomy prevailing will be like a redressal mechanism without spirit. Liberty for the parties opting for arbitration without equality being enshrined from the stage of inception to conclusion would be like a soulless process. The Arbitration Act, as discussed earlier, provide for adequate guardrails to ensure that arbitrators to be appointed are capable of independently discharging their responsibilities. The 6th and 7th schedule require the proposed arbitrators to disclose any circumstances that might reasonably affect their impartiality, including relationship with the parties, the counsel, or the subject matter of the dispute. In this scenario, since parties opt for the arbitration route to avoid redressal in court, minimal judicial intervention should be the norm. In my view, all unilateral appointments must not be declared void by way of declaration of this court. The 2015 amendment in section 12(5) itself provides for a specific waiver and express consent in writing, and the consent must be obtained after dispute has arisen. Therefore, it is abundantly clear that the agreement between the parties, provided it satisfies the specific waiver requirement under section 12(5), can effectively cure any concern about impartiality or independence in such cases. Adequate safeguards are provided within the Arbitration Act to ensure a level playing field as discussed in the preceding paragraphs, and therefore to answer the question in this reference, a search within the provisions of the Arbitration Act should first be made. In my view, the obligation of fair treatment should be grounded in the Arbitration Act rather than in the principles of constitutional or administrative law. The choice of parties in the arbitration should not be disregarded without compelling reason through judicial intervention, especially when the Arbitration Act itself provides clear remedies under section 12, 13, 14, 15 of the Act. It is only when there's complete lack of consensus between the parties that the court's interference under section 11 could perhaps be justified. Following the above discussion, the following are the conclusions. A. Section 18 applies to all stages of arbitration, including the stage of appointment of an arbitrator. The Arbitration Act does not provide for any special treatment to the government, irrespective of whether the arbitration is by or against the government. Unilateral appointment of arbitrators is permissible as per the legislative scheme of the Arbitration Act. There is a distinction between ineligibility and unilateral appointment of arbitrators. As long as an arbitrator nominated by a party is eligible under the 7th schedule of the Act, the appointment, unilateral or otherwise, should be permissible. It is only in case of complete lack of consensus that the court should exercise its power under section 11(6) of the Arbitration Act to appoint an independent and impartial arbitrator as per section 11(8), read with section 12 and 18 of the Arbitration Act. At the appointment stage, the scope of judicial intervention is otherwise extremely narrow. The independence and impartiality of arbitrator must be examined within the statutory framework of the Arbitration Act, particularly section 18, read with section 12(5). Public law of constitutional principles should not be imported to arbitration proceedings, particularly at the threshold stage of section 11. So there's a bit of a agreement, disagreement, and that's how it is. So,
an item on the point that there is a duty to constitute an independent and impartial arbitral tribunal. But I differ on the method by which we achieve two inextricable principles of the 9 principles I have put at the end of the judgment. One is about party autonomy, the other is about the duty to constitute independent and arbitral tribunal, which is different from the duty of an arbitrator to act judicially. This duty of the parties to the contract, I have culled out from the provisions of the Contract Act, Section 28, as well as Section 23 relating to public policy, violation of which would render the constitution of the arbitral tribunal itself void, because they are under a duty to constitute an independent and arbitral tribunal. The aspect relating to declaring the agreements entered into between the parties at any point prior to the scrutiny of the agreement would not arise. That will be encroaching upon the party autonomy. And I have held that it will be applicable only when an application is brought to the notice of the court, when the court will act judicially and see whether the constitution of the tribunal is independent and impartial. For this reason, I have also indicated that statutory incorporation of these duties, it is not necessary to apply public law principles evolved in constitutional and administrative laws. Sourcing these duty obligations from Contract Act and Arbitration Act is important to maintain the integrity of the party autonomy and restraint of judicial institutions. The power to ensure that the arbitral agreement is compliant of public policy requirements of establishing an independent and impartial tribunal is always of the court. This is the third principle I have mentioned. This principle is recognized and statutorily incorporated in the 2 acts. It is the duty of the court to ensure that the arbitral agreement inspires confidence and it will enable establishment of an independent tribunal. Neither public policy considerations under the Contract Act or the arbitration restrain the parties to the arbitration from maintaining a panel of arbitrators in any manner. However, the arbitration agreements enabling one of the parties to unilaterally constitute arbitral tribunal do not inspire confidence of independence and may violate public policy requirement of constituting an impartial tribunal. Court will therefore scrutinize the agreement and hold that they may be invalid if it considers it appropriate. The occasion for the court to examine the constitution of the independent impartial tribunal will arise only when the parties make the application under 11, 14, and 34. These 4 principles I have mentioned here. The rest of it is there, will be uploaded in a short while. I don't want to read them all of the judgment. Thank you very much.
Grateful to. Not,
The last word I'll give
Last-
to
I was-
yes,
yes.
Vikesh Roy. We can't part. Yes, we can't part. We can't part.
Not the Chief Justice.
Vikesh Roy.
One of the last book that I was reading was titled Cooking a Book. Now, as judges, we cook judgments, and I'll explain. You see, when you cook a dish, it could be tikha, meetha, khatta, all 3 flavors. And you try to balance while you are cooking a dish. So, at least in my judgment, where I have agreed a bit with the Chief Justice and agreed a bit with Justice Narasimha, I have tried to balance it. So it is a judgment which I hope the readers will find it to be khatta, meetha, and tikha.
Lord, your Lordship missed, my Lord, one taste. That is bitter.
I'm deliberately avoiding.
On the lighter side, my Lord.
Oh, right. I'm deliberately avoiding because today it happens to be the final day of working
Yes, yes.
as a judge
That's,
of the Chief Justice.
This was purely on the lighter side, my Lord.
Chief Justice is demitting office, and we know with his great talent, he will have enough meetha flavors of India to spread internationally all over wherever he goes, and wishing the very best to the Chief Justice CJI Chandrachud, who happens to be the classmate of mine. We joined, 4 of us joined together. The third one is parting company today from me. I'll also demit office in a couple of months. So wishing the Honorable Chief Justice D.Y. Chandrachud
Lord,
such
we will
a
be
great.
wishing my Lord the Chief Justice at 2 o'clock, Lord.
I just wanted to say something. I had the great opportunity of appearing before him and also sitting with him.
Yes, my Lord, that's
I must say that at both instances I failed to come up to, as a lawyer, extraordinary ability, as a judge, extraordinary ability, as we were all appearing from the bar, and his patience, his participation in the proceedings, whoever appears, it was amazing. And as I sat with him on the bench, it was even extraordinary. You know, in every matter, the openness with which he would hear the matter and the ideas that he will float, the way he would connect with life and then law is all extraordinary. I mean, my opportunity is extraordinary.
But
Thank
possibly
you.
your Lordship is the only judge on the bench who had both the opportunities. Possibly Justice Vishwanath had never any occasion to sit with my Lord the Chief Justice.
Extraordinary, extraordinary. There won't be any.